Welcome to our Real Property Seminar. Many people hate and fear this topic. My message for you is, this is not nearly as unpleasant as you might think it is. This is a topic that lends itself to a divide and conquer approach. If you think about real property as one great big mountain, it's a lot more intimidating than if you think of it as a lot of little hills, which is a lot closer to what the reality is with regard to this topic. The National Conference of Bar Examiners tells us that there will be 33 MBE questions on real property, and the examiners spread out the testable issues pretty much all the way across the outline. So, of the 33 questions, you will have roughly 6 or 7 questions each out of 5 different subtopic areas. The National Conference of Bar Examiners splits up those areas as follows. First, 6 to 7 questions on land ownership. And what they mean by that is estates, future interests, and landlord-tenant all fall under the National Conference of Bar Examiners umbrella about land ownership. Next, rights in land. By this, the National Conference of Bar Examiners refers to easements, covenants, and servitudes. Again, 6 to 7 questions on this topic. Next, the examiners turn our attention to the law of real estate contracts. Here again, 6 or 7 questions. But our consideration of real estate contracts really has a lot more to do with the law of contracts than it does with the law of real estate. So, as you study contracts law separate from real property, you'll see that we spend a reasonable amount of time paying attention to contracts involving real property. That substantial area of overlap is well worth making note of, and we'll touch on it again a number of times throughout this seminar. Next, the National Conference of Bar Examiners splits up real property into 5 sections. The fourth of these sections is mortgages. And here, the law of real property is really focusing our attention on secured transactions. Mortgages really is part of contracts law. We consider it as part of real property, but the essence of this material is dealing with secured transactions. It's a type of contract issue, not really a real property issue. And then, finally, the last of the 5 sections, according to the National Conference of Bar Examiners, is dealing with real estate titles. And this is where we're dealing with the statutes about recording acts, and we're dealing with conveyancing by deed and by will. So, again, the 5 areas of law as enumerated by the National Conference of Bar Examiners. Land ownership, by which they mean estates, future interests, and landlord-tenant. Rights in land, meaning easements, covenants, and servitudes. Contracts, mortgages, and titles. Now, as we go through this substantive seminar together, you'll see that I do not slavishly follow the National Conference of Bar Examiners outline. And I have got one really good reason for that. The National Conference of Bar Examiners approach is unreasonably confusing. It's very helpful to know where the questions are coming from. They are very straightforward in telling us that they've split up the material into these 5 sections, and they're going to test each section relatively equal in weight to the other sections. Fair enough. But the way that I have chosen to organize this material, I think you'll find to be far more straightforward and intuitively sensible. And you'll also see that my digressions from, or the differences between my outline and the National Conference outline, those differences are not so drastic. But I think of the law of real property really as breaking down into 4 categories, not 5. And you'll see that one of my 4 categories isn't even listed on the National Conference of Bar Examiners outline. So, the approach that I'm going to present in these videos will be as follows. Like the National Conference of Bar Examiners, I'm going to start out by considering estates and future interests, but I will not consider landlord-tenant law as part of estates and future interests. So, in the first of the series of videos, we'll talk about present possessory interests and the future interests that they are connected to. Then we will consider other forms of land ownership in subsequent videos. Next, we will consider land use. And here again, I am fundamentally tracking the outline from the National Conference of Bar Examiners. With regard to land use, fundamentally what we're concerned about here are easements, covenants, and servitudes. But also, with regard to land use, we'll consider an issue that arises really out of constitutional law, Fifth Amendment takings issues, and government regulations of land use. So, again, my basic approach starts out with land ownership, then we turn to land use, and then the biggest and most important category from my point of view is real estate transactions. I think that this is the central part of the law of contracts. And here, my approach includes in real estate transactions both landlord and tenant, and land sales, and mortgages, and titles. All of these issues are intrinsically tied up with the law of contracts. And so, if you're going through these seminars in the order that I recommend, you'll be considering real property before you consider contracts. And if that's the order that you're going, you'll see that our discussion of real estate contracts is a good introduction to contracts. On the other hand, if you've chosen to do contracts first, a not entirely unreasonable idea, then when you get to contracts here in real property, you'll see that many of the ideas from our seminar on contracts are replayed here. So depending on the order that you're going, it's either a preview or a rerun. Anyway, real estate transactions is where the real bulk of the points are. To my way of thinking, the law of contracts on the multi-state bar exam consists of real estate transactions and then everything else. And when we get into real estate transactions, the good news is this is some of the most straightforward and modern of the material in the outline of real property. The stuff about real estate transactions is probably the easiest material in what is otherwise a fairly complicated outline. Then the last category of my four-part approach to summarizing the law of real property is remedies. I still maintain that the law of remedies is the unspoken heart of the bar exam. Remedies is what allows us to explain to a grader what the plaintiff gets. So a plaintiff in a civil liability question has to have two things. They've got to have a theory of liability, and they've got to have a prayer for relief. Now, when the theory of liability arises out of the law of real property, that theory of liability may combine elements from real property and contracts, or real property and torts. And we'll see that real property law really touches on a number of different legal subjects. We'll see plenty of replays from the law of torts. We'll see that the law of contracts is really at the heart of what the National Conference of Bar Examiners is really concerned about with regard to the law of real property. But we will also see that the law of real property requires us to have some understanding of the law of wills and trusts. Wills and trusts issues are an intrinsic element of real property law. They are not huge issues, but they are present, and we need to be very acutely aware of them. Also, we see that family law issues arise in real property law readily. And real property issues commonly come up on these other subjects. You can well get a wills, a trusts, a family law question, or even a corporations question in which one or more of the litigants is concerned about an interest involving real property. So that old phrase about how the law is a seamless web is illustrated beautifully by the law of real property, because we'll see that the law of real property itself has a core of information, but then it goes off to consider contracts, torts, constitutional law, and, of course, wills and trusts, and even family law. So, as we consider remedies, we'll see that the basic remedies menu is going to be in full effect here. The basics include damages, restitution, and injunctive relief. And here, since the law of real property touches both torts and contracts, equitable remedies here in the law of real property can include both specific performance of a land sales contract or some other contract involving real property, but it can also involve a temporary or permanent injunction as a remedy to a tort theory of liability arising out of the law of real property. So, once again, remedies issues are omnipresent because the underlying theme of real property law is civil litigation. But we won't stop there as we consider remedies. A couple of special remedies associated with contracts also come up here in the law of real property, and those are rescission and reformation. Rescission is where a court will cancel a contract. Reformation is where a court will use its equity powers to fix a contract that relates to real property, since we're considering real property contracts here. We'll see that reformation and rescission arise more broadly under the law of contracts when we consider contracts separately. So the basic approach to contracts is, first, identify which area of law is being tested. Is it land ownership? Is it land use? Is it a transaction involving real property? And based on your diagnosis there, you will split the theory of liability up into elements. Remember that the defense is likely to have arguments both with regard to the theory of liability and with regard to the plaintiff's prayer for relief. So, a meticulous approach to recognizing and following the relationships between the parties and between the parties and items of real property is important. Also, here in the law of real property, as it's tested both on the MBE and on the essays, often it's important to keep track of dates, to keep track of a chronology of a relationship between the parties. Real property is actually a very interesting subject, and as we go through it together, I think you will come to agree with me that this law is not nearly as difficult as you might think it is.